Breaking news tonight, and this one is erupting through the United States like a constitutional earthquake. In a stunning 6-3 emergency ruling, the United States Supreme Court has just unleashed one of the most explosive decisions of the decade, catching every level of government completely off guard. This wasn't scheduled. This wasn't expected. This wasn't even on the radar for legal analysts who track the court every single day. It landed without warning, and the shockwaves are still rolling across the nation. Federal agencies are stunned. State governments are scrambling. Attorneys general are holding emergency meetings. And every courtroom from coast to coast is being forced to freeze, reevaluate, or outright reverse policies that were active just 24 hours ago. Nobody saw this coming, not Congress, not governors, not prosecutors, not even the state-level judges who believed their rulings were secure. The ruling hit like a legal detonation, shattering assumptions and ripping apart frameworks that had been cemented for years. And what the Supreme Court just did isn't just a legal correction, it is a constitutional upheaval that may reshape the balance of power between states, citizens, and the federal government for generations. The aftershocks are already spreading, and by the end of tonight's breakdown, you'll understand exactly why this ruling changes everything and why legal experts are calling this one of the most aggressive Supreme Court emergency decisions in modern history. To understand why this emergency ruling was even necessary, we need to rewind and look at the legal chaos that triggered the court to step in. Over the past year, lower courts across America have been bitterly divided. Conflicting rulings, opposing interpretations, clashing legal standards. Some states were enforcing strict rules while neighboring states were allowing the exact opposite, and nobody could agree on what the Constitution actually permitted. Federal agencies were sending contradictory guidance. Law enforcement officers didn't know which standards to follow. And lawsuits were piling up so fast that multiple appeals courts issued conflicting decisions within days of each other. What started as a single legal dispute exploded into a nationwide constitutional crisis. The Supreme Court tried to remain hands-off until one appeals court issued an order so disruptive, so far-reaching, and so constitutionally questionable that it forced the justices to intervene. This wasn't a normal petition. It wasn't a scheduled hearing. It was an emergency request coming out of a legal mess so severe that waiting months for a formal review could have created even more chaos. So the court stepped in fast, aggressive, decisive. But instead of simply stopping the confusion, their ruling detonated across the entire legal system. Policies froze. Enforcement halted. Regulations collapsed. And states with completely different approaches to constitutional rights suddenly found themselves dragged into the center of a legal storm. What makes this ruling even more explosive is the deep ideological split inside the Supreme Court. This wasn't a unanimous decision. It wasn't a narrow technical correction. The court's 6-3 divide is a warning shot, a declaration that the majority believes the government crossed a constitutional red line. The majority opinion was sharp, forceful, and uncompromising. They accused states and agencies of overstepping their authority, violating constitutional protections, and creating legal frameworks unsupported by the text, history, and tradition of the United States. Their message was clear. Constitutional rights are not optional, not flexible, and not subject to political moods. But the dissent? That's where the drama gets intense. The 3 dissenting justices blasted the majority's ruling, calling it premature, destabilizing, and even dangerous. They argued the court is moving too fast, interfering with ongoing cases, and undermining the ability of states to govern their own affairs. This ideological clash is now fueling political fires across the country. Governors are calling emergency press conferences. Senators are demanding investigations. Advocacy groups on both sides are mobilizing overnight. And legal scholars say this fracture inside the court could shape major constitutional battles for the next decade. The moment this ruling dropped, the legal landscape shifted instantly. Courts froze cases that were seconds away from enforcement. Agencies pulled back regulations they had defended for years. Attorneys suddenly lost the legal foundation they built entire arguments upon. And law enforcement is now seeking urgent clarification before making any further decisions. Some policies were halted mid-implementation, literally stopped in the middle of being enforced. Others were pushed back to earlier stages of review, forcing judges to redo months of legal analysis under the court's new guidance. Federal guidance documents are being rewritten. State codes are being reviewed. And attorneys are scrambling to determine which of their cases are now legally invalid. The shock factor comes from how fast the ruling took effect. No transition period. No gradual rollout. No delayed enforcement. One ruling and the system flipped instantly. This is why the word earthquake keeps coming up. The ruling didn't just adjust the legal framework, it blew open the doors and forced every state and federal entity to reassess how they operate. And the ripple effects haven't peaked yet. Now let's break down the constitutional core of the ruling, because this is where the magnitude becomes clear. The majority made one thing absolutely unmistakable: constitutional rights cannot be reshaped by modern preferences, new regulatory theories, or evolving political arguments. They grounded the ruling in strict text, original meaning, and historical tradition, a legal approach that has become the dominant force in recent Supreme Court decisions. According to the majority, if a modern regulation or policy does not align with the principles established at the founding of the nation, or at least have a historical analog rooted in early constitutional practice, then it stands on legally fragile ground. This is a return to foundational constitutional interpretation, a rejection of balancing tests, a rejection of public interest exceptions, and a clear warning that governments, federal or state, cannot create new powers simply because they believe they serve a good purpose. The dissent argued this approach is too rigid, too old-fashioned, and too insensitive to modern needs. But the majority was unmovable. The Constitution means what it meant when it was written, and the rights it protects do not shrink to accommodate new political demands. This principle is now the backbone of the ruling, and the reason states are panicking. As soon as the majority opinion hit the public, the fallout began. Governors from high-regulation states immediately expressed outrage, calling the court's ruling reckless and dangerously disruptive. Other states celebrated the decision as a victory for constitutional liberty and a long-overdue correction of government overreach. Meanwhile, legal analysts started mapping out which policies, laws, and enforcement strategies were now in jeopardy, and that list grows longer every hour. Courtrooms in multiple states paused ongoing cases and ordered emergency reviews. Attorneys rewrote entire briefs overnight. Advocacy groups filed new lawsuits using the Supreme Court's ruling as ammunition. And multiple judges have already signaled that prior decisions are now invalid under the new framework. This is not a ruling that tweaks the edges, it strikes at the core of how constitutional rights are evaluated. The fallout is national. The consequences are immediate. And the political firestorm has only just begun. Federal agencies are now in crisis management mode. Internal memos, emergency guidance updates, scrambles to rewrite enforcement protocols, overnight meetings where attorneys and policy experts try to determine how the ruling affects ongoing operations. State agencies are even more destabilized. Some states are quietly pulling down enforcement guidelines from their website. Others are openly defying the ruling and vowing to fight it in every legal arena possible. And a few states are attempting to rapidly pass new legislation, even though analysts warn those laws will almost certainly be struck down under the court's new standard. What you are seeing right now is a complete fracture between federal authority, state authority, and constitutional interpretation. And agencies know it. Within hours, major legal scholars began calling this ruling one of the most significant emergency decisions in decades. Some compared it to key pivot point rulings that reshaped national legal standards in areas like civil rights, criminal procedure, and interstate authority. Why? because the court didn't just issue a decision, it issued a directive that wipes out dozens of legal arguments states have relied on for years, old precedents, invalid, old interpretations, overturned, old enforcement strategies, unconstitutional. The court's ruling forces every judge, attorney, and lawmaker to reorient themselves toward a stricter constitutional standard, one that eliminates modern legal theories courts have used for decades. This is not a small shift. It is a full doctrinal reset point. One of the biggest concerns now is the domino effect. Legal experts predict that this ruling may topple dozens of existing cases waiting in the appellate pipeline. Challenges that were once considered long shots may now be fast-tracked. Lower court rulings that relied on now invalid reasoning could be overturned in rapid succession. If you imagine the legal system as a series of pillars, the Supreme Court just pulled the foundation out from under many of them. And once the first domino falls, the others follow. This ruling is already being cited in new filings across the country. Lawyers are rewriting motions. Judges are requesting supplemental briefing. And entire cases may be decided differently because the Supreme Court changed the rules in an instant. This chain reaction could reshape entire legal landscapes far beyond the immediate issue. If you thought the legal fallout was explosive, the political backlash is even bigger. Within hours, politicians from both sides issued statements that could not be more different. Some argue the Supreme Court overstepped and weaponized constitutional interpretation. Others say the court finally restored the limits that government should never have violated in the first place. In Congress, some members are calling for legislative countermeasures. Others are praising the ruling as a victory for constitutional fidelity. Governors are split down the middle, some applauding the decision, others condemning it as a threat to public governance. Advocacy groups have already begun mobilizing. Campaigns are being launched. Fundraising surges are underway. Legal defense organizations are preparing new battles. Protest groups are planning nationwide demonstrations. This ruling didn't just create legal shockwaves, it ignited political warfare, and this fight is far from over. The significance of this ruling goes far beyond the immediate issue. Legal experts believe it sets the tone for how the Supreme Court will handle constitutional cases for the next several years. The court has signaled a firmer return to historical tradition analysis, a rejection of balancing tests, a stricter interpretation of constitutional limits, a willingness to intervene when lower courts fracture, a readiness to issue emergency rulings when necessary. This means future cases, especially those involving constitutional rights, state authority, federal overreach, and regulatory power, may be decided under much tougher scrutiny. It also means that laws once considered settled may now be vulnerable to challenge. This ruling didn't just resolve one dispute, it created a new judicial roadmap. By now, it should be clear. The Supreme Court didn't merely settle a disagreement, they redefined the legal battlefield, they elevated constitutional text, they strengthened historical standards, they restricted government interpretation, they undermined modern regulatory theories, they established a new high bar for future policies. Every judge, every lawmaker, every agency, every court, they all now have to operate under a new constitutional regime, one that demands strict justification, historical grounding, and adherence to founding-era principles. The effects won't stop tonight, they won't stop this week. They won't stop this year. This ruling will ripple for decades. So here's where we stand. A 6-3 Supreme Court emergency ruling has just detonated across the country. Policies frozen. Courts disrupted. States divided. Experts stunned. And the legal landscape shifting beneath our feet. This ruling wasn't expected. It wasn't planned. It wasn't on anyone's radar. But it landed, and it landed with historic force. And in the coming days, we will see new lawsuits, new challenges, new political wars, new judicial interpretations, and possibly massive changes to constitutional law. Tonight was only the first shockwave. The aftershocks are coming. And they may be even bigger. Stay tuned, because if this is the opening chapter, the next phase is going to be even more explosive.